Thank you, Frank, and thank you to your center for inviting me here to talk about my thoughts not only on this year's iteration of the NDAA on the House and Senate side, but also the Qatari deal. And those two topics are inextricably intertwined, and you'll see why I say that during my remarks. And as Frank mentioned, I did have the privilege of serving in the previous administration where I was in charge of detainee policy, not just with Guantanamo, but all of DOD, so Iraq and Afghanistan. But before talking about the detainee-related provisions in this year's NDAA, and I will get to it, allow me to provide a little historical context, what people tend to forget, which will provide context for my remarks and why these provisions pop up every year in the House and Senate NDAA. Since 9/11, we've detained over 100,000, that's right, 100,000 detainees. The vast majority were in Iraq, 75,000 or so. About 25,000 or so were in Afghanistan, and in total there were 780 detainees at Guantanamo. Today there are no detainees in Iraq in our custody. There are no detainees in Afghanistan in our custody, and there's 122 detainees in Guantanamo from 18 different countries. The big three populations at Gitmo were the Afghans, the Saudis, and the Yemenis. Today, more than half of the detainees at Gitmo are Yemeni. The youngest detainee at Gitmo right now is a 30-year-old Yemeni, and the oldest is a 67-year-old Pakistani. Of the 122 detainees at Gitmo today, 57 have been cleared for transfer or release by the Obama administration. Now, we focus on the Obama administration, but we tend to forget that the Bush administration transferred or released over 500 detainees from Guantanamo, and almost all the other detainees from Iraq and Afghanistan. We also can't, as conservatives grounded in fact and reality, overlook the fact that detainees who were first brought to Guantanamo, some weren't enemy combatants, and we released them early on. They just weren't who we thought they were. And also we have to be forthright, honest, and direct about the fact that some detainees were mistreated at Gitmo early on. That's a fact. Now, there have been 3 Supreme Court cases dealing with detainee rights, including the latest Boumediene against Bush, which held that the detainees at Gitmo, nowhere else, but at Gitmo, had the constitutional right to the writ of habeas corpus, which means that they can file and have filed a federal claim in the district court here in Washington saying, please release me. And they've done that. They've been very well represented, and most of them have had their petitions for writ of habeas corpus denied because, in fact, of course, they are unprivileged enemy belligerents, or as the Bush administration used to call them, unlawful enemy combatants. Potato, potato, same critter. When I was working at the Pentagon, I was tasked with pulling together a classified plan of how to close Gitmo, if in fact President Bush had decided to order it closed. And remember, in 2006, President Bush did say publicly that he wanted to close the facility, but he never gave the close it order. So, like many things in the Pentagon, we have contingency plans, and that contingency plan still exists. And I can't go into the details of it, but it's important to understand the broad contours of it, because that will put into sharper focus the detainee-related provisions in the NDAA this year. 4 letters, LLPD, legal, logistical, political, and diplomatic. 4 buckets, 4 large topics, 4 areas of work that you have to work in simultaneously and that are inextricably intertwined with each other to get the facility closed. Now, each of those 4 topics would require a law review or a multi-hour course to teach, and I'm not going to go into the details of that, but I want to focus on one aspect of it, the P, political. The main reason that President Obama failed to close Guantanamo, in my opinion, is because in his first year in office, he did not spend the political capital necessary to do so. And political capital, as you know, is evanescent. It's transient. You either have to spend it quickly or it goes away. In other words, he had a window in his first year in office, when the Democrats controlled the House and the Senate, to work behind the scenes, make the case to them, and then put an action plan in place, and then spend the political capital to force its closure. He didn't do that. He failed. So this Monday morning rewriting of history, that is the Republican obstructionism, is the reason Gitmo's not closed, is just belied by the facts. How do we know that that statement is true? Well, in his second year in office, when the Democrats were still in control of the House and the Senate, it was the democratically controlled House and Senate that passed amendments to the NDAA that did 2 things. 1, prohibited the president from spending any money to bring Guantanamo detainees to the United States, and 2, spending any money to purchase or modify a facility in the United States for the purpose of housing Gitmo detainees. And we've seen a rerun of that movie now every single year, and indeed this year we have similar provisions. Every year since then, Congress and the White House have gone back and forth with similar Gitmo-related amendments to the NDAA. And so before jumping into this year's smorgasbord of detainee amendments, let me paint the big picture for you from my perspective. This isn't Heritage's position. This is just my perspective from my limited experience. As conservatives, we should not be focusing exclusively on the place of detention, or as I call it, the zip code. But we should instead focus on the legal capacity to detain the enemy during wartime, any war. Gitmo is a professionally run, safe, secure, humane facility. I'm sure some of you have toured it. I've been there multiple times. But where the enemy is housed, I would argue, is much less important than the legal ability to engage in military detention during wartime. And we are in a state of armed conflict. We are at war. Another point. The administration argues that Gitmo is, quote, and this is recent testimony, quote, used by violent extremists to incite local populations, unquote. In other words, that it's a major recruiting tool for terrorists, and therefore it should be closed for that particular reason. Conservatives, some of them, say that Gitmo is not a recruiting tool for the enemy, and they point to the fact that there was no Gitmo during the first World Trade Center bombing, there was no Gitmo during the 1998 East Africa Embassy bombings in Kenya and Tanzania, there was no Gitmo when the USS Cole was bombed in 2000, there was no Gitmo, of course, on 9/11. I would argue that both sides are actually oversimplifying the matter, and here's why. The fact is, in my opinion, the existence of Gitmo has, to quote the first DASD for Detainee Affairs, Matt Waxman, quote, hampered cooperation with our friends, such as critical counterterrorism tasks as information sharing, joint military operations, and law enforcement, unquote. That doesn't mean and doesn't destroy the reasons why people firmly believe that it should be closed, and it certainly equally doesn't destroy the reasons why we should keep it open. But we have to be honest about what its existence has done. At the same time, as Cody Poplin and Sebastian Brady, who write for lawfareblog.com, pointed out yesterday in their analysis of jihadist propaganda, written in English, Gitmo does show up in some propaganda, but has, quote, grown far less salient over the last few years and has never played a big role in any terrorist group's propaganda compared to the issues that really animate those groups, unquote. They conclude, quote, it is hardly clear that Gitmo's closure would matter much so far as concerns the contents of jihadist propaganda, unquote. I think they nailed it. I think that's exactly right. From news reports today, we read that the Obama administration is ready to transfer up to 10 detainees this month. So whether they close Gitmo finally by one grand gesture or attempt to do so by attrition, the Obama administration's obviously still working to shutter the facility. But I think their window actually has passed to do so. And for the first time, it appears that Congress, or at least the Senate, is willing to construct a legislative path to closure. Recall that in the FY14 NDAA, Section 1039 required the administration to provide Congress with an assessment of whether transferring Gitmo detainees to the United States could result in eligibility for relief from removal under the Convention Against Torture, require release from immigration detention or asylum of withholding of removal, or any other constitutional right. DOJ provided Congress with that assessment on May 14th of last year. This year, the Senate has 7 detainee-related amendments so far, dealing with detainee issues. They're contained in Section 1031 through 1037. And as in previous years, they have a provision that prohibits the use of funds to construct or modify facilities in the United States for the purposes of detainee-related detention of Gitmo detainees. That's a perennial favorite. But then, notice, they include amendments that anticipate the movement of detainees from Gitmo to the United States or to other countries and attach a series of conditions to that. For example, Section 1033 reinstitutes the Secretary of Defense certification before transfer mechanism, which had lapsed or lessened in the last couple years, requiring the SecDef to give 30 days notice to Congress before any transfer and certify, along with the Secretary of State, that the government where the detainee is going is not a designated state sponsor of terrorism or an FTO, that they can maintain control over the facility where the detainee is housed, that they can control the person, that they will take actions to mitigate the threat that he poses. The receiving country must agree to share that information about the detainee with us, and Congress gets to see any MOU between that country and us. More interesting is Section 1032, which is the legislative equivalent of an olive branch to the administration to bring Guantanamo detainees to the United States with a lot of strings attached. It would permit the SecDef to transfer detainees to the United States for trial or detention, but it prohibits those transferred from applying for asylum or from accruing any lawful immigration status. It limits judicial review and requires the administration to produce a comprehensive plan on the disposition of each detainee, including costs, legal implications, threat assessment, and a plan for what to do with them if or when the armed conflict ends. Because, of course, the sole basis for detention even in wartime is that you're in a state of armed conflict. Once that plan is submitted, and this is key, Congress must affirmatively approve it, or it lapses. In other words, it doesn't go into effect. If the Democrats don't like that, they just want the administration to be able to submit the plan, and then it happens. Another section allows for the temporary transfer to the United States for emergent medical treatment. I actually think that's a good idea, and I can go into that in the question and answer and give you some examples from the past where we had serious medical situations. Section 1037, which I call the Taliban 5 or Bo Bergdahl provision, requires the administration to cough up any MOU between us and any country who received detainees in the last 18 months. That's where the Taliban 5 deal is really affecting this legislation. Now, the House-passed NDAA takes a much harder line, as you might expect. Their Section 1034 requires the administration to cough up all known communications between Gitmo grads, a term I coined many years ago, and individuals known or suspected to be associated with a foreign terrorist organization. No doubt that was triggered by one of the Taliban 5 in Qatar, news that he tried to reach out to terrorists to communicate while he's in house arrest. Section 1035 in the House requires a quarterly report on recidivism. The next section is a flat-out prohibition on transferring detainees to the United States, and the next section prohibits the expenditure of funds, the perennial favorite, to construct or modify facilities here in the U.S. Section 1038 is the one with fangs or big teeth. Really hamstrings the administration, to mix metaphors. It prohibits them from transferring detainees to combat zones as defined under the IRS code. The House also has a SecDef certification section. And here's another one of the Taliban 5 provisions. It's Section 1040. And that requires the SecDef and the Attorney General to provide correspondence and legal analysis regarding that transfer. In the House's estimation, the administration has not been forthcoming about that. And so if they don't cough up that information, the law would prohibit the obligation or expenditure of 25% of the funding for the Office of the Secretary of Defense. That hurts. So here's the big picture, and I'll stop and take your questions. One, Gitmo has been and continues to be a political hot potato. That's clear. Two, the Bergdahl deal and the lack of 30-day notice of impending transfer in violation of a statute, by the way, has created ill will between the administration and Congress on both sides of the aisle and has lasting implications. Three, the recidivism rate, which is about 29% of known or suspected to have gone back to combatant activity, continues to be of concern to Congress. Four, the Senate is actually more open to bringing detainees to the United States than the House. And last, five, unless the President goes big and spends huge political capital in one grand move, Gitmo most likely will be open in some form, at the very least for military commissions, in the next administration. So to sum up, the administration will, in my opinion, transfer as many cleared detainees off the island as they can, as quickly as they can. Quick is a relative term. Secretary Panetta only signed off on 4 transfers. Hagel signed off on 44 transfers. And it's hard to know how many of the remaining 57 who have been cleared for transfer Secretary Carter will certify and be able to transfer in the remaining 19 months of the administration. Thank you.
Cully, thank you. Could you address one other piece of this, which I must tell you is the one that worries me as much as what you've said, which is that whether he can get all of these guys out someplace or not, that he will commit as part of the normalization of relations with the Cubans to give the whole thing back to them. And maybe if, having been there, which I've not, you could address the strategic significance of that facility beyond the detention aspects.
Well, make sure if you offered a trip to Gitmo, Frank, that you're offered the round trip.
The round trip, indeed, yeah.
And you can consult me as your ad hoc legal counsel on that trip
Thank
offer. Yeah, sure. Actually, I've written about this at heritage.org. The lease arrangement with the government of Cuba goes back to 1901, and in fact, we took possession in 1903 of the 45 square miles in southeastern Cuba. It's a unique lease arrangement in the sense that it requires both sides to agree to renege on the lease for the release to be let out of the lease. Moreover, it's not just a lease like the one you and I have had with our landlord over the years. It's actually embedded into law under what's called the Platt Amendment, and the Congress passed that and then amended it later into law so that now, in my opinion, the President doesn't have the unilateral executive authority to give back Gitmo simply because it's a fig leaf in some sort of, or a little widget in a bargaining of normalizing relationships with Cuba. You would have to get Congress to repeal that law or pass a different law. Of course, we've seen this president violate all sorts of laws across a whole host of subjects, so who knows what they're willing to do. But the lease arrangement, which we've complied with our side, among other things, requires us to have a fully functional and operating naval station. We've done that since 1903. It requires us to make a lease payment. We first made that payment in the form of gold bullion, which was part of the lease, and eventually switched over to a check, which the Cuban government, under the regime of then newly elected elected is a relative term, Fidel Castro in 1958 cashed the check one time and then has never cashed it again. But we believe under the doctrine of laches, which is a boring but important legal doctrine, they're stuck because they acknowledge the legitimacy of our check and our lease. The facility at Guantanamo, as I laid out in more detail in my heritage piece, which I'm more than happy to send to Ben and he can send around to your distinguished group, Frank, has served a vital strategic purpose for the United States. It was a training ground and an important warm water harbor in the run-up to World War I. In the run-up to World War II, the Atlantic Fleet actually did joint training exercises there and wintered at Cuba. The Marines have had a constant presence at Guantanamo and have done many exercises there. Obviously, for the Bay of Pigs invasion, Guantanamo was a staging point. Since then, in the recent decades before 9/11, it's been a vital intelligence platform for counter narcotics and counter drug and other intelligence reasons. Not only is it used as a refueling station for not only the Atlantic Fleet but other Coast Guard and other vessels. So the point I made in the paper, and I think the writer was exactly correct, is that regardless of whether the detention mission goes away or not, and someday it will, the naval station at Guantanamo should remain in our possession because we don't know what other mission sets will come along down the road. And, look, Fidel Castro bitched and moaned in '58 about the existence of us at Gitmo. They've been bitching and moaning ever since. Raul Castro bitches and moans about it. They're saying that for domestic political purposes as much as they probably do want it back as well. But we can have normal relations, whatever the hell that means, with Cuba and still have the naval station at Guantanamo. And there's absolutely no reason that I've seen that we should give that back.
Is the lease in perpetuity?
It's in perpetuity, yeah.
Great.
It's about $4,000 and change a year, so it's well worth the money.
Good deal. Ben?
I have a question about Congress forcing the President to release memorandum of understanding. Is there an issue there with separation of powers? And the President getting his privilege?
Yeah, so it's a good question. It's a question that has come up in years past when things like this related to detention issues have arisen. Look, do a thought experiment for a moment. Pretend this is, we're in the second term of yet another Republican president. And for some reason, that president wants to close Gitmo, and it's the Democrats who want these MOUs. We would be here, and Frank would have some pointy-headed lawyer up here talking about separation of powers and how that's an infringement upon executive privilege, and there may be a national security exemption that they could put forward. And if you believe in that principle, I think the principle should apply both sides. It's not a one-way ratchet. And so when I had the privilege of serving, we did lots of transfer agreements with lots of other countries, and we never disclosed the contents of those executive branch, which is a core executive branch function, to the Congress. We would brief the Congress routinely on detainee matters. In fact, I went up there every quarter and went to this building and the other side of the hill and showed them, virtually everything we could, especially correspondence between us and the International Committee of the Red Cross, which was, there was a lot of it. But I think that, you see in previous signing statements when President Obama has signed the NDAA, he's taken issue with detainee-related provisions, among other things. And I think that's going to be a deal breaker. Now, whether he has the chops to veto the entire NDAA, which that hasn't happened yet, or whether it gets sort of watered down during conference, which is more likely, we don't know. But I think, as people who believe in the rule of law, who believe in the separation of powers, who believes that the commander-in-chief is invested with plenary power to prosecute wars, and that Congress has a specific function under Article 1, Section 8 to declare war, but the President has additional powers under Article 2, I think you're right to point that out. And so I don't think that they're going to be forthcoming with the granular detail. They may paint broad strokes to make enough people happy on the Hill, but I don't think they're going to produce the actual memos.
Anyone else? Could I ask another then? You mentioned 29% recidivism.
Known or suspected to have committed.
Okay. Do you think that's actually the tip of the iceberg, or do you think that's a realistic projection as to what the rest of them are up to at the moment?
Yeah. So despite the fact that I look young, I'm 51, and I've been a federal and state prosecutor for most of my career, and a judge. And if you step out of the terrorist detention context and you just walk down the streets of D.C. or any major metropolitan city, and you talk to cops or prosecutors, there is absolutely no way of knowing how many prior felonies or misdemeanors a person who's in the dock being prosecuted for something has committed. All you have is a rap sheet. And the rap sheet is just the number of times the person actually got caught and then went to court and then was held accountable. There are multiple other times where they did it and they got away with it, they did it and they weren't turned in, they got away from it, they got found not guilty. And so why would you suspend the laws of common sense? And when you're looking at the terrorist detention context. So one of my favorite movies is My Cousin Vinny. You guys seen My Cousin Vinny? You remember when they're cross-examining the guy, they said, "Did the laws of physics cease to exist on your stove?" Right, when they're cooking grits. And so my answer is, did the law of common sense cease to exist when we're looking at recidivism rates for Guantanamo detainees? Of course not. So all that number has to be wrong. And the number actually has to be higher. It's not going to be lower, but we don't know how much higher. So that's the only way to answer that question honestly. It's a good question. And it's something to keep in the back of your mind when people push back on that number.
And did you do during the Bush years some of the Saudi rehabilitation programs, or was that a creature of this?
Did I do them? No, I wasn't a terrorist.
No, I figured that was not the case, but just checking. But beyond your own personal submission to this program,
yeah.
Did you have direct insight into
yes.
how effective it was, and
yeah.
would you
let me address
any
that
credibility today?
Yeah. So before I came into office, a guy named Matt Waxman, who I referenced, he was the first DASD for detainee affairs. And by the way, he's been nominated to be the general counsel for the National Security Agency. I think he's an excellent nominee for that position, having clerked at the Supreme Court as a Rhodes Scholar. He's very, very, very solid candidate for that position. Under Matt's tenure, they structured the deal with Afghanistan. And remember, the big three populations were Afghans, Saudis, and Yemenis. And Afghanistan's way different than Saudi Arabia, as you know. The deal we struck first with Afghanistan, without getting into stuff I can't get into, was essentially we'd send a few test cases back, see whether these guys re-engaged, and then we'd send more back over time if they had some relative success level. The Saudi deal had already started to be put in place through the hard work of Secretary Gordon England and others before I came to office. So when I came into office, that deal had been struck, yet we had not sent our first batch of Saudi test cases back. So when I first came to work in the building, we picked the least likely to reoffend in a small batch of them and sent them back to Saudi Arabia. And recall, because I know you and I have talked about this before and your organization has written about it, that they actually had a so-called religious re-education program before 9/11 for hardened extremists. And they retooled it after 9/11, so it had been in existence. And so we started sending a trickle of these folks back into that program and ultimately sent many more back. And of course, it's not like any program that deals with human beings. It's not perfect, and it certainly does not have a perfect track record. But there was immense political pressure, as you remember, especially after the Republicans lost the House in 2006, to really cull the number of people at Gitmo so that you can get down really to the most hardened of terrorists. And so, right or wrong, good or bad, this is the first war where during war we've been releasing the enemy as we were capturing more throughout the entire war. It's just a strange anomaly, an historical footnote in otherwise history of warfare. So we did that. Yemen's a different problem because they didn't have a successful re-education program. President then Saleh made it very clear when we talked to him, without quoting him or getting into sensitive diplomatic discussions, that they couldn't mitigate the threat that the Yemenis posed if we sent them back from Gitmo, the Yemenis back to Yemen. And so that's why there's 70, 80, 90 Yemenis still at Gitmo. And of course, to your point, which was an excellent presentation, Yemen doesn't really exist anymore, right? You can add that to the list as well. So there's no country really to exercise capacity to detain these guys.
Well, I'm just going to keep going if you're not going to join me. I just have to ask, how could Wahhabis, who are about as hard extremists as they come in this scheme of things, possibly be moderating hardened extremists that we're sending back to be religiously re-educated? Did that ever get really wrestled with?
There's an interesting dynamic that goes on on the politics of this. One is you hear from the other side, the closed Gitmo camp, by keeping them there in custody, you're just making them more radical, and it's becoming jihadi university. And then in the next sentence, they're saying, but you really got to send them home because, and they fill in the reasons why. And it's like, well, if you think they're getting worse, you think letting them go is going to make them better? It just again defies logic. Look, I've watched the interrogations there. I've reviewed every detainee's file at Gitmo and some of the others from Iraq and Afghanistan multiple times for Gitmo folks. There's just some number of them who are never, ever, 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 ever going to drop their pack and their mission. because leopards don't change their spots. There were, early on, as I said, not only some people who just weren't enemy combatants, but others who were lower level folks who realized after they got a taste of detention, to being deprived of their livelihood as whatever it is they did to scrape up an existence, and their family, that, that wasn't worth the lift. But you're right. I mean, you answered your own question in asking it. So I mean, a child molester molests children and then they get caught and they come back out and there's a high recidivism rate. Thieves have a high recidivism rate. Spousal abusers have a high recidivism rate. Terrorists, you fill in the rest of the blank, right? So again, don't suspend your common sense when you look at these problems. Sir?
What is the status of the KSM trial? And do you expect him to be executed anytime soon?
Well, let me answer the last part of your question first. No. So I don't expect him to be executed anytime soon. He would first have to be convicted at a trial that takes place or plead guilty, and because it's not typical to plead guilty to a death penalty eligible offense in military trial, I think that there will be a contested trial. There have been 8 military convictions. Several of them have been overturned. The 5 co-conspirators in the 9/11 trial are still in pretrial litigation. They've argued several hundred pretrial motions, and those continue. KSM is joined with 4 other co-conspirators, including al-Hassawi, who's a financier. Brigadier General Mark Martins is the chief prosecutor and a brilliant legal scholar in the sort of modern-day mold of Robert Jackson, who was the chief prosecutor for the U.S. in the Nuremberg War Crimes Tribunal. Al-Nashiri, or Al-Nashri, as he prefers to call himself, is the bomber for the USS Cole. That case is on hold pending what the D.C. Circuit does in a case called Al-Balul. I won't get into the legal niceties of it, but the case has had over 250,000 pages of discovery produced by the government to the defense. They've had numerous pretrial proceedings. And there's another guy who has been charged. Charges have been referred against him named al-Iraqi. And he happens to be the only Iraqi who was ever brought to Gitmo, to my knowledge. So I think that KSM case is probably the most complicated case in our nation's history, above and beyond the Boston bombing and the Oklahoma City bombing case, which we just celebrated our 20th anniversary of, way above and beyond that for all sorts of reasons. Do I think as a former federal prosecutor it could have been brought in federal court? I do, and I have immense respect for federal court. Do I think military commissions is the right venue for him? I do. I think we need both those venues available to hold accountable folks. You got to look at it on a case-by-case basis. Sir?
Kind of impression, your comments, I wanted to make it explicit. There was kind of a certain pressure. You didn't have much of a choice about some of the actions you took in letting that go. I often believe that everyone has signed off whenever a person's cleared for release. I want to understand what that means when people say that everyone has signed off, DOD, the administration, and so on, even the CIA, they say. Does that really mean that everyone agrees that there are no threats, or that under the existing taken for granted political pressure, that people have no choice but to fail to raise objections that will pass those pressures?
Yeah, let me make 2 points, and I hope this answers your question, or at least scratches most of your itch. First off, there's never been a risk-free transfer from Gitmo. Period. To quote my old boss, we don't know what we don't know about certain people. I mean, it's not like they showed up, pulled out their military ID card and said, "Hi, I'm Bob Smith, and I've only used this name, and here's my DNA, and you can prove it." That never happened. These guys came with multiple aliases. They changed their stories lots of times. They didn't have an ID card, and so there's never really been a risk-free transfer from Gitmo. There have been some risk-free releases, which is a different process, early on because they literally were not engaged in combatant activity. In all of the transfers that I was involved in, and I can say fairly safely before I was there and then after I was there through the Bush administration, we knew that there was an element of risk in making a transfer recommendation. And during the Bush administration, the Deputy Secretary of Defense, who was Gordon England, was the DCO, the deciding civilian official. So he and he alone ultimately made the decision after input from Southcom, JITF, DASD, DOD, Office of General Counsel, the Joint Staff, the Chairman, and other constituent components. After getting the transfer or don't transfer recommendation from them, he would take a 360-degree review of each detainee package and then decide himself what's in the best interest of the United States. I never asked the Secretary of England. I said, where are you on the dial, the risk dial? I met with him a lot, but there are certain questions you just don't ask. He's a dear friend, and I think he's a hero, and I think he was a great DepSecDef. I know other people may disagree. I just respectfully disagree. But he was tagged with that job. Things changed in the Obama administration. The Obama administration, to their credit, said, you know what, there's not one place in the government where you can get everything about detainee X all in one spot. And so they did some what I would call housekeeping. And they forced the interagency to bring all the information they had about each detainee into one spot. So that when they did take a look at the detainee, they had, frankly, probably better information than we had because it was all in one place. When I viewed detainee packages, I viewed the package in front of me. It was pulled together by my staff. I would often have questions as a former prosecutor and say, I need you to follow up on this, I need this, I can't make a recommendation until you give me this. But in the Obama administration, they had this forcing mechanism. But ultimately, at the end of the day, they're looking at the same detainee we looked at. They're looking at the same information we had. And it was just a matter of upping the risk calculus. If the boss here, the president, says, we're willing to take more risk, and that's translated down through the secretary, then everyone else along the way says, I guess they're willing to take more risk. So it's not as if they found exculpatory DNA or they found an alibi witness. They decided that the remaining population of detainees that existed, they're going to use an even finer scalpel and decide of those remaining 200 and some that they got when they came into office, who are really the worst and who are less worse. And then they started working their way up the pile, and now they've cleared 57. Notice that whenever they make an announcement of a detainee transfer, they say that the receiving country will mitigate the risk that they pose, because they do pose some risk, and that's why they put these assurances in place. If the Taliban 5 weren't risky, they wouldn't have warehoused them in Qatar for a year and put them under house arrest and been monitoring them. You think these guys down in Uruguay are enjoying living in their tent out in front of the American embassy begging for money? So I'm quite confident that what happened along the way, and this gets to your political pressure question, is that no one came to me and said, hey, Stimson, hey, hello, wake up, McFly, recommend transfer. I used my best judgment on each and every package that came to me. I made a recommendation to the DepSecDef, and he exercised his required judgment. And I think, so when they say everyone agrees, if you internally set the bar here, like if they don't pose this kind of threat or more, then the preference is to recommend transfer. You can get a lot of transfer recommendations. If the bar is here, there's a different calculus in terms of how much risk you're willing to accept.
That same, I can't remember what it's called, the evaluation board of the agency.
Right. I don't know the answer to that. So I can't answer. I think that, remember, the Taliban had been asking for these 5 guys for years. In fact, Panetta writes about it in his book. And I think Gates even wrote about it in his book. Both good books to read. But I don't know whether these guys were scrubbed through it. In fact, I think if they had been scrubbed through it, the answer was no. Right. And they weren't on the approved transfer list. And so I think they probably, my guess is they probably went through it, and the answer was no, not yet for this administration. But then the opportunity to get Bergdahl back arose, and they took the deal.
Cully, last quick question, maybe 2 parts. One, you mentioned that there are within this group, and you're familiar with who all these characters are, people who are never going to give it up. And
right.
Even the president has said you can't bring to trial. Now, maybe that's the same group, maybe it's a different subset, but there is some hardcore that I think even he has conceded.
Yeah, the administration says like 20 to 30. Yeah.
They're going to have to incarcerate someplace, and
Right.
I guess they have in mind bringing them back here at some point if they can find a way. Do you have any idea how that works? If they do bring them back here, do they in fact get constitutional rights beyond habeas corpus and become eligible for being released by judges? Second, these are by all of the past indications the worst of the worst that are left. Do you have any reservations about the 57 that they've cleared?
Let me answer the first question first. So I've read the DOJ analysis on the immigration, Convention Against Torture, asylum, and other constitutional rights question from Section 1039. It's a solid document. It's not completely convincing to me that they're right, only in the sense that they put a lot of trust in what they think judges will do. I was a judge. Judges change their mind based on facts, based on the law as it changes. What they don't answer either, Frank, is this question. And I think that's why this provision that the Senate has is good. When the war ends as a legal matter, in other words, when we're not in a state of legal armed conflict against al-Qaeda, what happens then if they're here? Because I could easily envision an immigration judge saying, wait a minute. And I can easily envision people representing them making the argument. I would make this argument if I was representing them. I got him in custody. He was clearly a terrorist. He's clearly al-Qaeda. But President X has just declared the armed conflict over as a legal matter. It's over. What? He's in legal no man's land now? You can't be in legal, bless you, you cannot be in legal no man's land. We've tried to send him back to country X. They say heck no. We've tried country Y. They say heck no. At the very least, let's put him on house arrest with an ankle bracelet and let him go live over by Gaffney's house. I'm not being cute, but I'm really trying to make a serious point here, right? So it's an attempt at serious legal analysis. I just don't put the same faith. I mean, who would have predicted in 2002 when Gitmo was stood up that the Supreme Court would rule contrary to Eisentrager, which was the 1950 Supreme Court case, that held that enemy combatants captured overseas with no interest in the United States do not have access to our federal courts? Who would have predicted in 2002 that the detainees who showed up in Gitmo that January 12, 2002, would later, in 2008, have the Supreme Court confer upon them the constitutional right to habeas corpus. I don't think many people would have predicted that. So I don't have the confidence that they do in that. So they got to answer when the war ends, what happens. And I don't think they really can answer that with a high degree of confidence. They can do their best, and they have really smart lawyers in the Office of Legal Counsel. I just don't know. The second question was?
Just the follow-up to the first was, could they be sprung well before the war ends?
Well, I think to this gentleman's question earlier, the president enjoys broad constitutional powers and that during wartime, and that includes the right to decide or try to decide where to house the enemy, who the enemy is broadly defined, who is an enemy, and then when to release the enemy, even if it's during wartime. And so I think, to my point earlier, let's say this year the can't bring him to the United States provision ultimately prevails in conference, and that stays the law. That's not going to stop the president from sending 30-day notification requirements up to the Hill. And remember, the 30-day notification requirement is, Mother, may I? It's just, hey, we're doing it within the next 30 days. Okay, it's not a permission slip. And then just start offloading these dudes as quickly as possible. And, can you envision this president the week before he leaves office with Josh Earnest standing up for his last farewell before the press, saying, oh, and one last item. An hour ago, a plane landed in Yemen, and it contained the remaining 98 Yemenis from Guantanamo. Thank you very much. Have a nice day. Yeah. And what's the remedy? 50 hours of talk news and TV hits for people expressing outrage, and then we swear in the next president and life goes on. I mean, the remedy is political. So there's no legal remedy to that. And
the second question was just knowing what you know, are those 57 people the worst of the worst, and is there a real risk of letting them go?
Well, I think that there's a risk for every single person down there.
You said that, but I mean more than just an acceptable risk, that there's actually...
I don't think that Khalid Sheikh Mohammed and some of and all the folks facing military commission are ever going to be free people again, nor should they be. I think there are others in that 20 to 30 category that the Obama administration has identified as the highest of high risk, that the left calls the forever prisoners, should ever be let out before the end of the armed conflict. But again, when the war ends, unless there's some other legal remedy to hold them, in other words, prosecuting them for an articulable crime under our jurisdiction or another jurisdiction, you got to let them go, and you got to recognize that, and you got to be clear-eyed about that.
Cully, thank you for extended conversation on this. I appreciate it.